Assistant Administrator General, the Superintendent of Police, Nabukera Diana, the Vice President of Uganda Law Society, members of Council joining online, members of Uganda Law Society, the public online, our staff at the ULS, ladies and gentlemen, good morning. My name is Christina Awori, the CEO of Uganda Law Society. On behalf of the Uganda Law Society, I'm delighted to welcome you to the 18th Radical Rnblive weekly press and public engagement. Today, we join the rest of the world to commemorate the United Nations International Day of Families under the 2025 theme, Family-Oriented Policies for Sustainability Development towards the Second World War Summit for Social Development. This year's theme is timely, call for reflection and action. It reminds us that strong, well-supported families form the bedrock of sustainable societies. As the legal fraternity, we recognize that families thrive where there is justice, protection, and access to legal protection, especially for the most vulnerable. We are therefore proud to convene this platform that encourages dialogue around policies that center the family unit in the development of agenda. We are honored to be joined by an esteemed lineup of speakers who bring unique perspectives of this discussion. Allow me to warmly welcome Mr. Henry Kulova, the Assistant Administrator General, the Superintendent of Police, Nabukera Diana from the Child and Protection Unit of Uganda Police Force, Ms. Sheila Tuyashingula, our own, the Head Legal Aid and Pro Bono Services at Uganda Law Society Legal Aid, and Mariam Nansuksa, Manager Legal Aid. As we move towards the Second World Summit for Social Development, it's our hope that the conversations like these ones contribute meaningfully to the national policy, disclose and inspire multi-sectoral collaborations in protecting and empowering lives. Thank you for making time to join us today. I encourage all of you to engage actively and take forward the insights we shall gather today in our work and advocacy. Thank you. I now take this opportunity to call Head Rule of Law to the podium to take us through how the day will end. Thank you.
Thank you, CEO. All protocol observed. My name is Apio Afra. I'm the Head Rule of Law. In line with commemorating International Day of Families, our first speaker will take us through DNA and family law in Uganda, the role of the Uganda Police Force, the intersection between law enforcement and family law is vital in ensuring justice and protection within family settings. The Uganda Police Force, through its Child and Family Protection Unit, is at the forefront of responding to domestic violence, child neglect, and paternity disputes. During this session, our speaker will shed light on how the police handles DNA-related cases, the challenges encountered, and the role of the police force in supporting family-oriented justice. Today, we are joined by Superintendent of Police, Nabukera Diana. She works with the Child and Family Protection Unit at the Naguru headquarters, which she joined in 2018. She has attained several courses in the field of child protection understanding sexual and gender-based violence, online sexual child abuse, among others. She's also a trainer of trainers on child protection and making her an expert in her field. She is deeply passionate about ensuring that women and girls access the justice they deserve. She holds a bachelor's in social work and social administration and is currently pursuing a master's in gender studies at Makerere University. Join me in welcoming Ms. Diana to take the podium.
Thank you very much for this brief introduction about me. I'm so delighted that I've been picked as the first discussant on my arrival. So it makes it extremely great, and meeting such a congregation, I think it's my first time meeting the Uganda Law Society. But I'm glad we are here, and we normally collaborate in the different spaces where we reside. First and foremost, as she has introduced my names, I'm Superintendent of Police Nabukera Diana, a child and family protection officer working at Police Headquarters Naguru. As a department, when we received the invitation through the Acting Commissioner, Child and Family Protection Department, SCP Atwaire Maureen, I was so delighted that she actually delegated me to come and speak to you on the role of police on issues concerning DNA and family law. First and foremost, DNA is a very common case that is being reported to our stations. And oftentimes you find out that the main traumatized third party, who's the child, is at the end result. If the two parties have not agreed, the child, who's the third party, will at the end of the day be left somewhere. And that's why you find most of the times you see cases of street children arising, so many children leaving homes because what they witnessed, it wasn't on a good note on their side. So as the police, we are guided by the Uganda Constitution. That is 1995, when we are handling some of these cases. And on top of that, we have the Children's Act. I think it's now Cap 62, right? And then we have so many legal instruments like the Penal Code Act, where we draw our guidance when it comes to issues of parentage. And as a department, it falls under the Directorate of Chief Political Commissariat, but it's being helped with other line departments when it's dealing with issues of paternity, that is DNA. So along with that, we have the sexual and gender-based violence, where we normally work with, and also the community policing department, where we reach out to the masses and sensitize parents, caregivers, the children, on issues related to family law and DNA. So what is our role as I go to the main background? First and foremost, we do investigations and prosecution of some of these cases once they come in. How do we do them? I can give an example of child neglect. So many of these cases do not come directly as DNA, but as couples discuss with you, once they bring in and lodge in a complaint of maybe child neglect or domestic violence, one will ably come up and show the reason as to why I have not been providing is because the mother of the child or the father of the child told me this child is not mine. So what do we do as police? We compile a case file, and we do not leave it at the police level. We do work with the Office of Resident State Attorney, those are the ODPPs, who peruse this file and maybe guide us on what to do, either to refer these people to court or maybe a DNA can be carried out. So prosecution side lies on the side of the ODPP. As for us, we, the police officers who cook at the very initial stages, do the thorough investigations, then the prosecutors or the RSA can ably guide on what next step can be taken. Secondly, what is our role? The second role in issues relating to DNA, we do offer advice and information. Oftentimes, I will ably want to give practical examples because these are the very cases that we interface on a daily basis. It's not a movie, but these are the cases that come in directly. So how do we offer this advice and available information? Given it's like a couple walks in and at their home spaces, they come in when they have agreed that we need to do a DNA, but they come to us seeking for further information on how it can be partaken. For instance, we can tell them or we can advise them, Ministry of Health apparently, let me shortly take you back, Ministry of Health apparently approved 3 laboratories, and one of them is the GAL, that is the Government Analytical Laboratory. Then MBN, and also for the police side, when it comes to issues of criminal cases, we do have a forensics laboratory, whereby high-profile cases could be murder as a result of murder, because at times domestic violence, due to DNA, at times you might find one of the persons, their lives has been lost. Or in the meantime, maybe a child needs, the family needs a test. So we normally give information to the clients who might come in and they do not want to open up a case file, but they just need that information on where to go to. So that is the available information that we can ably tell them. But there are those who come and they are in a disagreement. Those are the ones that we ably network with other stakeholders and the legal service providers to help, like the Family and Children's Court. So we give them information on the available laboratories that they can ably go and access such services, and automatically just know some of these laboratories come with a fee. So this one is being done to those who come and they are in agreement and they are willing to go and have the test being done on the child. Then thirdly, what we do is the referral. Referral is part of our work. We do not ably finish up our work as a sole institution. We normally partner with other agencies and other stakeholders. First and foremost is the Uganda Law Society, the legal aid service providers, whereby most of our clients are too vulnerable that you find out that even processing a court fee, because even recently they said issuing a DNA, you must go through the court. But what of these people who are too vulnerable that they cannot even afford the medical fees? So we do work with some other stakeholders who can ably push for this, like the Uganda Law Society and other legal service entities that can ably help these victims. So our main goal is to see that the best interest of the child, which is the child welfare principle, is being put at the center. Sorry. Can I proceed or I wait? It's okay. So as I proceed? No, okay. So our role, the third role, is that the referral, as I was saying, that some of these cases, yes, we do the investigation bits, but there is a limit whereby as an institution, there are other service providers that can ably go ahead and give the necessary service to some of our clients. So that's why I was mentioning the people that we closely work with are the legal aid clinics, the Family and Children's Court, to see that victims can ably get the necessary service. And of course, that one comes with some other short challenges, but at least we've seen that most of them are being helped in that line. Then the fourth is about collaboration and network. I think it's not far from the referral that we ably work with other stakeholders to see that justice can be attained to the child, to the family members, and the rest of the people involved. Then we do basic guidance and counseling. We are not professional counselors, but most of the times our clients come in and they need that emotional support. That is through the counseling bit of it. And why do we do it is our main goal is upon reconciliation. Not breaking families, but we want to see that families thrive where there is mutual understanding. However much a DNA has been partaken, and there are those that results turn out to be negative, and you see a family getting separate ways, or even at times it goes an extreme, as I earlier said, the murder cases coming in at the end of the day. But what is our purpose or our role? Our role is to guide these people, that it's not the end of the day. A child remains a child, however much that has happened, but we want to see that the main goal in this is we reconcile and then see that the child's interests are being focused on as a major goal. Then fourth, or the fifth one, is the follow-ups. These cases come in, we do not just sit on them, work on them, and then leave it there. How do we do these follow-ups? Once we refer them to the different laboratories, in case the RSA has guided, we do go an extra mile and find out how were the tests, were they out, and then if they go to the Family and Children's Court, some of these parties, as I said, they are too vulnerable. Most of them, they do not have that monies. So we do go an extra mile and maybe give a courtesy call, or even go there and meet and find out if they were helped. Or even so, in the DCC meetings, normally court has those, they normally organize the DCC meetings where every entity is being called upon to discuss on how the legal process of some of these cases move. So we do make follow-ups to see that if there is anything or any progress or anything lagging, that we can ably come in and maybe support or maybe help out. Then we do, the last one is we do compile some of these cases. We do not leave them at that. We do make annual, we do make monthly, we do make quarterly reports. Why do we make them? Is maybe for further follow-up and also for further future programming. And then we see which district or which region or which division within Kampala reported the highest number of such cases. And then as an institution, how can we, or a department, how can we ably dive in and see where we can ably see that we can support in and maybe guide, and then we see other interventions that can be made. So there are 7 roles per now as a department that we do. As I earlier said, our department is all about establishing, seeing that the rights of children, women, girls, boys, and other family members live in a harmony family environment. And family law is one of it that we ably put our focus on to see that we are guided by the law. We do not do things just in a mere way, but we are ably working on them and following what the law says with the guidance of other legal entities that we normally work with. We do all these roles, but they also come with challenges. As I earlier said, that issues of DNA involve some financial constraints. And as I earlier mentioned, that most of the clients that we receive, the biggest percentage are the poor, who cannot ably manage the court fees. So if a DNA, if they issue that a DNA should pass through the court system, how are these people who do not have even any single coin? Because remember, the cases that we normally receive are child neglect cases or neglect of duty, as they changed it recently. And you find out the majority of them, they do not have the finances, the transport to move to those where the courts are. It becomes a challenge. At the end of the day, you'll find out that this child or this child cannot get any other justice. But you find out that the other party will get, the anger will boom up, at the end of the day, one will pierce maybe something there, and then you find out a dead body, and those are the murders that we are registering. So issues of finances is becoming a constraint to us, and also secondly, there are certain cultures, the negative cultural aspects in certain areas, that for them DNA, even if they just see a child, that is not their child. So there are those negative cultural rigidities that are still happening in certain communities, that issuing a test or going for a test, it's an abomination. So that calls for massive sensitization. As I earlier said, that we do partner with community policing to move to communities to sensitize people. DNA is not a matter of traumatizing a victim or a child, but we want to see that at least a child has a family and has a parent that they can ably cling on. Then lastly is about the inadequate temporary shelters. Why am I bringing so that most of the times when we receive these clients, when they're in disagreement, at times what will happen next at home, it will not be a very good land-on. So some of the shelters being availed, like in Kampala, we do have action aid, and I think for the domestic violence cases, which I believe it cannot be enough. And when you look at the children homes even around, some of them are not enough, because we normally refer there children who have been abandoned on the roads, children who are being in abusive environments. So you find out placing these children, which is being decided on by the probation and social welfare officers, at times they also get tied up, and you find out that some of these children are left maybe at certain avenues. So I think those are the challenges, and we recommend for more financial support, for more sensitizations, for more trainings, to see that children live in an environment which is violence-free. DNA does not separate a child from their parents that they have grown up with, but we want to see that children smile in a healthy relationship. And we want to see that some of these cases that come in at the end of the day, and you see the main cause being the DNA, it shouldn't make our clients or our people that we normally come to us behave in a very different and weird way. So at least I can give such a brief background, and those are the roles as per the invitation, and we ably continue to work together, because this is not a one-man's show, a one-man's entity, but when we work together, that if I know legal service provides this, I can ably refer these clients to this. If it's supporting this, then I can, if police is investigating, let these other agencies also come in, such that we are all achieving one major goal, to see that we are in a violence-free environment. I thank you.
Thank you so much, Afande, as we are normally called. We thank you for your wisdom. We thank you so much for your presence and breaking down the topic of DNA. It is a very complicated topic that also disturbs the public. And we really thank you for your elaboration about the issue. And we shall hope that the statements you've made in regard to the need for further collaboration will be taken heed of, especially by us, the Uganda Law Society. Excuse me. You'll excuse us. Afande has a small piece of information to share before she can take her seat again.
Thank you. I think this was an oversight. She actually reminded me. We do have a gender-based violence toll-free line, which is being managed by our CFPOs, those are the Child and Family Protection Officers, who are sitting at police headquarters. It works 24/7. So clients can ably call in and any other person. So it's on 0800 199 195. Then if you see that it's a delay, we work with 116. 116 was integrated also to handle also GBV cases, that we can ably see that we can have a faster run into a case being reported to. So you can use that to that, and also the Sauti 116. Thank you.
Thank you once again for that information, especially the toll-free line 116, as has been given. We appreciate. Ladies and gentlemen, by the name Robert Jurua, I am from the Rule of Law Department. I will aid the department to moderate this session. And we're moving on to the next item. But before that, we want to take cognizance of the presence of the Vice President of the Uganda Law Society, the most able Anthony Asimwe, who had earlier on communicated a few challenges on his way. So, Mr. Vice President, you're most welcome. Thank you for gracing the occasion. We are en route and continuing to the next item. Having heard from the Uganda Police, we are going to hear from another very important office that handles the same matters. Remember, our theme today is really about commemorating International Day of Families. For those that are joining us after we began, we thank you, especially those that are online watching us and on various platforms. Today the theme is family-oriented policies for sustainable development towards the Second World Summit for Social Development 2025. And to take us into the next agenda item, we are going to be discussing a topic, the DNA and family law in Uganda, the Administrator General's role in fostering resilient families. DNA and family law in Uganda, the Administrator General's role in fostering resilient families. And as family dynamics evolve and science continues to shape legal practice, the role of DNA evidence, as has been said, in resolving succession, guardianship, and paternity disputes is becoming increasingly significant. The Administrator General, or AG, as we know, the Administrator General's office plays a critical role in managing estates and protecting the rights of beneficiaries, especially children, as provided for under Article 108 of the Constitution, whereas Article 109 provides for the powers and the functions of the Administrator General. So in this session, we will hear from the Assistant Administrator General on how DNA testing is being integrated into estate administration processes and the broader efforts by the AG to foster family stability and protect vulnerable family members. To help us break this down to solubility, we are joined by Mr. Kulova Wesaka Henry, who is the Assistant Administrator General, as well as the Head of Litigation in the Administrator General's office, where he has worked for the last 14 years, and he is also an assistant lecturer at the LDC, teaching family law practice and land transactions. He holds a Master's of Laws in International Commercial Law from the University of Salford, Manchester, as well as a Bachelor of Laws from Makerere University and a Diploma in Legal Practice from the Law Development Center. Ladies and gentlemen and distinguished guests, allow me welcome Mr. Kulova Wesaka Henry.
Thank you very much, Robert. All protocol observed. DNA is a very contentious issue, and all of us who are in this room, and even those who are online, can be victims or candidates, either during our lifetime or even in death. I'm sure you have heard of cases of exhumation of bodies just for purposes of determining who is going to take a certain plot of land. As they have introduced me, I'm Henry Clover. The Administrator General was not able to come in person because he had a prior engagement, and he delegated this task. So I'm here to present on this topic on behalf of the Acting Administrator General, Mr. Victor Manzi. You should ask yourselves, if your father, for example, left a will bequeathing to you property, and he states, children, these are my children, and he lists them in his will, 10 of them. And having listed the children, he goes ahead and gives out property to those children. And unfortunately, he passes on, and a dispute arises as to whether one of those is a child of the late. And a DNA test is done, and it is discovered that Henry, who was listed as one of the children and given property, is not a child of the late. What happens? On the face of it, it looks simple, but it can be one of the most contentious issues, especially after the death of the testator. Think of another scenario. Somebody dies and they cremate their body, and of late we know cremation. So somebody dies and they do cremation, and the ashes of his body are splashed in the sea, in the lake, in the river, whatever the case is. Thereafter, a contention arises as to whether one of the children that person left belonged to him. Of late, in the courts of law, it is becoming clear that the deceased's body is the most accurate source of genetic information. And we have had courts order for exhumation of bodies so that they can get the sample from the source. So what happens where there is cremation? The ashes were splashed in the sea, in the ocean, so we don't have a deceased's body. Looks simple, but can be very contentious. The sources of information for DNA. I'm going to talk about examples, but I'm not going to mention names for confidentiality. Everything I'm speaking here are live examples that happen in the office of the Administrator General. Can we get samples from the pillow that somebody used? Can we get samples from the hair, the garments, underwears, trousers, toothbrush? Actually, there is one, and in the Administrator General's office, we have the toothbrush case, where a toothbrush of a dead person was used to get samples for DNA testing. As we talk now, the case is still in court, very contentious. I wanted to just give that, those are like teasers for you to know the contentious nature of the subject that we are discussing. But before I go into the details to unpack that and then relate to the family and how, because the topic was DNA and family law in Uganda, the Administrator General's role in fostering resilient families. What a beautiful topic, because when I checked the definition of resilience, we shall all agree that indeed DNA is causing certain strains on families. Resilient, when I looked at resilient, is the ability to withstand or recover quickly from difficult conditions, capable of withstanding shock, enduring strain without getting permanently injured, ability to recover or adjust to misfortune, ability to regain one's shape or position after bending, stretching, or compression. That is a resilient person, or in this matter, a resilient family. If you ever talk to a family member or family members whose dear one was ever exhumed, the grave broken, the coffin broken, and the body or the bones, the remains as it may be, accessed for purposes of samples, you'll agree with me that we are dealing with a very serious issue. Such families never recover. Looks simple until you are a victim. They never recover. I wanted to briefly talk about, first of all, the role of Administrator General, then I delve into this. As you all know, the Administrator General's office is a statutory body established under the Administrator General's Act to manage estates, administer estates of deceased persons, and not only deceased persons, but also missing persons, persons with mental illness, and so on and so forth. They issue certificate of no objection. The Administrator General issues certificate of no objection where it is not going to administer an estate. So the family members agree to administer the estate themselves, and that is what we encourage, so that they go and get letters of administration. The Administrator General also acts as a public trustee, especially where minors or children below age of 18 and persons of mental illness are involved. We all know that the family is a basic unit of society, and therefore a prosperous and stable society depends on a stable family. But we also know that inheritance lies at the core of any family unit. Inheritance is something that you never understand. When it comes to inheritance, people are not the same again. It does not matter how rich a person is. When it comes to inheritance, it is more of like a spiritual issue. I have handled an estate where one of the beneficiaries was in Germany, Ugandan, but in Germany and doing very well. And they left land in Gomba. And the gentleman was in Germany, but insisted nothing should happen. No person should be appointed an administrator until I come back. So we told him, no, but you can even be there. These days there is Zoom. He said, no, I need to be there. Those people are going to sell that land in Gomba. A small piece of land. And he had to put in a ticket, return ticket, come. Actually, at that time, the family court had not yet started Zoom, so he put in a ticket, came. The matter did not take off. It was adjourned. He went back. He put in a ticket. He came back. This time, he was lucky the matter proceeded. Now, that tells you that in a family like that, first of all, this is not a person who is there for money, but there is something else. There is something that happens when somebody dies and property is left, regardless of the value. So inheritance lies at the core of the family unit. And if not properly handled, disputes lead to domestic violence, depression, psychological torture, and in extreme cases, even homicide. People have killed fellow family members because of a chivanja that is not even more than maybe 10 million shillings. So, because of that, and the fact that succession law, for example, and I'm going to be limited because family law is broad. So I'm going to limit myself to Administrator General's succession or inheritance under Ugandan law is determined by two things mainly: blood and marriage. Those are two things that bind any family, even all of you who are here. Whether what or what, your family, the two things that bind you: blood, marriage. So the only person who comes into the family who has no blood relation is the wife. Because she comes from outside and joins the family of blood. So she's the only one without blood connection. So the law says she's connected there by marriage, by law. The third would be an adopted child, because an adopted child also, when he comes into the family, by virtue of adoption, he becomes a biological child and inherits, yet he has no blood. So that one is adoption. So because of blood and marriage, and mainly blood, issues of DNA have become center. In other words, to benefit from an estate, for example, of a person who has died without a will, you must be connected to the deceased by blood or marriage. And that's where issues of paternity become center stage, because now you are not. In other words, the moment they are saying you are not the child of the late, what they're actually meaning is that you are not entitled to share. That is it. You are not entitled to share. But as we shall see later, paternity goes even just beyond sharing. Somebody just even to know who their father is. So, but before DNA came in, because DNA was not here many years ago, people determined the paternity differently. And the first one was, the matrimonial bed, what they call the matrimonial bed, which is a common law principle, that children born in wedlock are presumed to be children of that marriage, are presumed to be children of that husband and wife. Common law. Presumption. And court cases have established that. Tendo Sunita versus Annette Tumwebaze Mugasha. Court affirmed that principle that there is a presumption that children born in wedlock, that is in a valid marriage, are children of that marriage. Presumption. And courts, we are going to share a few cases where courts are actually confirming that and declining DNA tests. That was the Tendo Sunita case. There is the Gaza Zo Atara case versus Maureen Namara. Again, court confirmed that a child born in wedlock is the seed and product of that marriage. We are talking of family, so we have to be specific. Product of that marriage. And court went ahead to say that even if the child was conceived before the marriage, or the child was conceived during the marriage but born when the father has died, all those are very contentious matters. They can happen to all of us. So you are conceived before the two get married, and then the child is born in the marriage. The presumption is that is of that marriage. Of course, we know that it may not. But the law is presuming. Why did the common law presume some of those things? Because of what we are going to discuss. And courts are declining to order DNA tests in some of those cases. So the first one, before DNA, was that marriage. If there is a valid marriage, children born in that marriage are children of that marriage. The second, before DNA came in, was acknowledgement. Now, acknowledgement is also provided under our law. The Children Act provides for acknowledgement that if there is any document that a parent has written in a form of a deed acknowledging so and so is the father, or the father is writing something and acknowledging so and so is the mother, an acknowledgement was also taken as a form of determining paternity. The third was evidence, but this one is mainly in the Muslim faith, but also in our customary settings. Evidence, resemblance, presumption, resemblance. This person resembles the other. Bodily features, physical features of the child to confirm family relations. Use of photos. There is a case again, the Office of Administrator General, again, it has not been decided, where the High Court had determined the paternity based on the photos of the deceased. Looking at the deceased and looking at the person alleged to be or not to be a child of the late. There are presumptions of paternity under the law. Presumptions. A birth certificate. That when you provide a birth certificate mentioning the father and the mother of children, of a certain child, the presumption is that those are the parents, or that is the father. Presumption of paternity under the Children Act. Instrument of acknowledgement that we talked about. Court order of maintenance. If a court has ever ordered that you be maintained in a certain estate. Declaration of parentage. Express or implied reference in a will. We had talked about a will. I write a will and I say, this is my child. These are my children. It is a presumption of paternity. And a statement made by a deceased person to a person in authority. That if you ever made a statement to a person in authority, for example, Minister of Religion, or even the Administrator General, you make a statement that so and so is my child, are all prima facie evidence of paternity. Now, why did DNA come in? Because what we have talked about above is just presumptions, prima facie. In other words, it is not conclusive. So the Constitution guarantees a child's right to know and be cared for by their parents. The right to know your parents, under Article 34 of the Constitution. DNA tests are allowed under Ugandan law. The Children Act, Section 112, allows DNA tests. And even courts have now gone ahead to hold that in the current scientific era, we may not have to rely on photos and resemblance. Because actually, we have had again another scenario where the child resembled the deceased. But the child was for the brother. Because the brother resembled the deceased. The uncle, now that would be the uncle. So courts have realized that these other modes that I've talked about may not be conclusive. So case law to that effect, the Muzora John case, where they say, no, in the scientific era, DNA offers the most accurate information and linkage. So it is an injustice, for example, under succession law, for somebody who is not a beneficiary to benefit. It is an injustice. But it is also an injustice for somebody who is a beneficiary to be disinherited. So DNA helps in establishing that blood linkage and protects minors, especially because those are very vulnerable. Afande was talking about the minors. She's very right. They are the most vulnerable people in all this scenario. So that is how we can protect these minors. As I conclude, the challenges posed by DNA and their impact on the families cannot be overemphasized. We don't have a robust regulatory framework to guide DNA tests. The methodology of testing. Now, the methodology of testing is because family members can actually all agree that let us do tests on all of us. We are 8 children, let's do tests. But the disagreement is on how. Disagreement actually is now on the methodology. How? Let's exhume the body. Then the others, we cannot. How? How can we exhume our father? Just because of 2 acres? So the disagreement there is on methodology. And people have gone to court. When you read the cases that I referred to before, the Tendo Sunita case and the Gaz Atara case, you find that people are now fighting on methodology. How do we do? Let's exhume. And in one, the judge ordered for exhumation. In one of the cases, judge ordered for exhumation. And I've been in a number of orders for exhumation. How does that leave the family? I had talked about where the body cannot be found. Cremation. The ashes are in the Indian Ocean. So you test me and how we test. So now what? We test her and say, she's the daughter of X. Me, I'm not. How? What is it now? Where is the source? Even me, I don't. believe that you are a daughter of my father. Now, those are issues that come in with siblings. When they say we test, all of us, because even me, I don't know whether you are a child. In Buganda here, those of you who are Baganda, you'll know, and I've met so many of these cases, the hair. When I joined in 2011 in the Administrator General's office, one of the first cases, and at that time DNA was not, was the hair, who was very confident. You know, hairs in Buganda are not like hairs in other regions. The hair in Buganda is actually, that is the real hair. When you read about the history of hairship, that a hair is actually, first of all, he takes everything. The idea is that the hair is supposed to take everything, and then through a generation, property goes through the generation without leaving that family. So his son also takes on, and the cycle continues. So the hair was very confident, said, that one is not our brother. So it took so long, and when now DNA came, because it was a very long succession dispute, when DNA came, incidentally the hair was not. Out of, I think, 8, 6 were not. Now tell me, is such a family ever going to settle? Wouldn't we have been better off without actually that DNA test? In that example, I think so. But everybody has an opinion on that, because family law is personal law, so it is a very emotional law, unlike company law. Because with the company law, Parliament can amend the Companies Act, and we don't know. Even as lawyers, we may not know that they have amended it. But succession law and land law, you'll have the barazas on radio everywhere discussing. But no one will hold a baraza to discuss whether we should have the one-man's meeting in a company. If that is the amendment, there will be no baraza. But as to whether, for example, your land should be taken before you are compensated, that one, the barazas will be there. Family and land are very sensitive matters. So in that matter there, the hair, and by the way, people go into depression. Because if you are the hair and you knew, you were even saying, they should test only. They should actually get the sample from me. I'm the child of the late, I'm the hair. And test and see whether, because I'm the deceased. I'm the deceased. So they should test and see whether you are having our blood. If it comes out that you are not, is such a family ever going to recover? So courts, then of course alleged corruption, fake and manipulated results. People have to now pay a lot of money. I know of a family which took confirmatory tests to South Africa and Canada. You can imagine. Yes, they couldn't trust our laboratories. South Africa and Canada, mainly those are the countries they take. So, DNA, in my view, should not be ordered as a matter of course or as a routine matter. And actually that was confirmed in that case of Atara, where the legally wedded wife petitioned for letters of administration, mentioned her children, because those are the ones she knew, 6 of them. 2 who were born outside challenged the application for letters of administration, saying that they are also children. And those two said, all of us should be tested. And the court, in my view, rightly refused, rejected. Why should you drag people who are not complaining to court for tests? Adults, 40-year-olds, and so on and so forth. So the court said no. First of all, it applied the presumption of marriage, that these ones were born in a marriage, so they are presumed. Some of these things are contentious, like I said. I'm sure people are now thinking about that and said, but they might not be. Yes, but the presumption is there to protect family cohesion. So the court was like, no, we cannot. It is you, the two, who should be tested, and not these 6 who were born in wedlock. So in conclusion, I think use of DNA in the modern era is indispensable. All of us know that. However, it should not be casually ordered for as a routine, given the grave impacts on the family cohesion. DNA tests, once misused, can lead to family breakdown, fatherlessness, clanlessness, especially now like in Uganda here, disinheritance. It should only be used in deserving cases, for example, where babies are mixed up in hospital at birth. So if at birth in Mulago, babies are mixed up and you don't know, maybe that is a good case for testing. Also may be limited to children born out of wedlock, or where family members, all of them agree to test. Exhumation of bodies should be discouraged and only ordered for in exceptional circumstances. Presumption of paternity of children born in wedlock should be emphasized to promote family cohesion. DNA tests on adults who are not complaining about their parenthood should be discouraged. First of all, it infringes on one's privacy, and then established a robust legal and regulatory framework to govern DNA testing. That was my discussion.
Wow, thank you so much, Council. We appreciate that very elaborate discussion on the topic DNA and family law in Uganda, the Administrator General's role in fostering resilient families. Council, for you to know, you have ably represented your boss. We appreciate the information that you have shared, and your teasers were very shocking to the public. We are being watched and attended to by various individuals. Words like bequeath might not be known by the public. That means to give or to donate, and then to cremate is just another form of burying, where a person's body or the deceased body is burnt to ashes, and the ashes are the ones that are buried. Just for that information. Thank you so much for the reference to the cases, the Tendo Sunita case. I personally remember it. Then the Atara case, but for the public to know, you can access these cases on a platform called ULI, Uganda Legal Information Institute. There's a platform that is created online. You can simply go and type that name, and details will follow for your information. Just for the public to know, the Uganda Law Society is mandated in the Uganda Law Society Act under Section 3 as one of its objectives to promote, protect, and assist the public in Uganda in all matters touching, ancillary, and incidental to the law. So while we are doing this, we're ably implementing the mandate that has been given to us under the Uganda Law Society Act, and we are only honored to be interacting with such bodies and government departments that come to aid in our assistance. So thank you once again, Office of the Administrator General. We look forward to interacting further with you and get that assistance that is necessary as we help to keep families together and avoid disintegration. Ladies and gentlemen, esteemed guests and the public, we appreciate your time with us. We are moving forward to the next agenda item, and it's equally interesting, but also in the same theme. We are tackling families and integration of the DNA. Our next topic is headed Protecting Uganda's Children Through Legal Aid. Your contribution matters. Protecting Uganda's children through legal aid. Your contribution matters. To help us break this down into solubility, we are going to have the Uganda Law Society Legal Aid and Pro Bono Department, which project offers legal support. Thank you so much. I got a little bit of a communication in the difference of program. We are going to request to take questions that have already come, of course. We also encourage questions for the speakers because their discussions are quite detailed, and many a time we offer to allow a platform for questions. We would like to direct questions to the two presenters from the Uganda Police Force and to the Administrator General's office. You will know that we have audience online, and there are questions that are coming from that side. One of them goes to because it's just been the Administrator General's speaking, we shall direct the first one that comes from Senior Counsel Philip Karugaba. We thank you so much for following us. We appreciate your time. We don't take it for granted. Alongside Senior Counsel Kunya, we appreciate you. Thank you so much for following up on us. The question goes, as you were speaking, Counsel, the current speaker, can a negative DNA test disentitle me from a bequest given to me as a child of the testator? I'll read again. Can a negative DNA test disentitle me from a bequest given to me as a child of a testator? Counsel, that is for you. There is a microphone on your left that you can activate if it's well with you.
Yes. Yes, thank you for that question. Probably in my legal career, this is one of the most challenging questions I've always interacted with. As I was teasing, I left it open actually when I was teasing in my introduction, that if somebody leaves a will and mentions A, B, C, D, my children, A, I give A my property in Kololo, B my property in Gwaise, and on and on and on. And then A, who was given the property in Kololo, the siblings, after the death now, the siblings are like, you are not. And you'll know why, by the way. You know the motivation why they are targeting that A. Usually also the value of the land. So they say, A, you are not a child of the late. We need to do DNA to know whether you are a child of the late. Because remember in the will, the deceased is saying, the following are my children. And A is one of them. So, there are two schools of thought. I'll give my view later. That if you go into the mind of the testator, what courts are at times called upon to, intention, that if this man was to resurrect and finds out, and they do the tests when he's now alive, he has resurrected, and they show him the results, DNA tests, child A is not your child. So the first approach is that would the deceased person, now who is alive, remove the gift from A? Remember, these are contentious matters because we are speculating. The man is dead. He has left behind. That's why the courts insist, even the Supreme Court recently insisted that we should obey the wishes of the deceased as they are. We shouldn't try and put in emotions into it. So now the first school of thought that says, if the man came back and actually realized this is not his child, would he have given him the Kololo house? In other words, would he remove it from him? Majority of people would say yes, which is an emotional argument because they're like, it's not his child. So he gave him thinking that he was his child, and whereas not. Now, that is one school of thought. Some people think that a DNA result should nullify a bequest. Me, I have a contrary view. Because unlike Jesus Christ who resurrected, for us when we die, we die. So we don't want to speculate. Okay? We don't want to speculate. Some men actually know that such a child is not his. Some men know that. So that is also another argument. There are some men who know that the wife came pregnant. And they talked about it and they came to closure. And the man actually loves this child as he does the others. So if he has given him in the will as a child, in my view, the will should be interpreted as it is. The will should be interpreted as it is. Very contentious, because I'm sure people would want to fight that up to the Supreme Court. We are happy that the Supreme Court already has indicated that wishes of a deceased person shouldn't be tampered with. Actually, the Supreme Court was even of the view that it can even deviate from the law. Because when you read that recent Supreme Court decision, a testator can even modify provisions of a law in his will. When we know, for example, that it is only executors who can sign, and then somebody says, no, so and so should also be a co-signatory. So that would be my answer to that very contentious issue.
Thank you so much, Council. We appreciate. There's another question for you, if you may. The question reads, from the same persons, from some Council Philip Karugava, when parents of an infant agree to conduct a DNA, who looks after the interests of the infant? When parents of an infant agree to conduct a DNA, who looks after the interests of the infant? Please.
Not very clear, because if parents of an infant, because even before the DNA is done, the law is presuming paternity. So you have actually, both of you have a legal obligation to look after a child until the true parentage is determined by court. So, to me, I think parental responsibility subsists until court makes a decision, for example, and declares somebody else to be the father or the mother, whatever the case may be. So before that declaration or proof that is a child of one of those, both of them have the parental responsibility over that child.
Thank you very much. Another question, I'm sorry. It reads, Mr. Kulova, you mentioned that exhuming bodies of the dead to do DNA tests is greatly discouraged by your office. Also, case law discourages this practice. For example, in the case of Mpumwire Magambo versus Amanda Magambo, miscellaneous application number 293 of 2023, where the High Court of Mbarara stressed that, quote, a person who has died must be treated with respect. It is immoral and illegal to disturb human remains without lawful authority. In your discussion, you have, as the Office of the AG, what initiatives are being taken to discourage the disturbance of the dead in confirming paternity? Is there any sensitization being undertaken to the public? Thank you.
Yes, the Office of the Msojono does nationwide sensitization through, for example, we just concluded one where we met the stakeholders in, I think it was West Nile, Western Uganda, and Eastern Uganda. And all this is aimed at sensitizing the public about these contentious issues, including the amendments to the Succession Act, which were recent. So yes, by the way, even for us, ours is to just discourage, but exhumation can't even be authorized by Administrator General. Exhumation can only be authorized by court, pursuant to a court order. So yes, we are dealing with sensitization because this affects the whole country, so the work is enormous. But yes, that is something that we are currently sensitizing the public through our agents, the chief administrative officers, because those are our agents at the district, which cascades into the sub-county chiefs. All those are our agents, and we always interact on topical issues.
Thank you so much, Council. Are there any physical questions in the House? Yes?
Thank you so much for the discussion. And personally, I have, as a legal practitioner, I have a lot of worry of what is ongoing as per the discussion that we have had. The issue of presumption of children being in as a result of a wedlock being a conclusive matter in court, it's something that is going to bring a lot of problems in this country, which we are already facing. We have seen the current case that we have, I think it was the Kitintale case, where these two are married and they finally find out that some of the children are not the children of the family. And as the DNA was being ordered to be carried out, whatever happened, we all know there was a murder of a toddler. So these are problems that we have that we cannot run away from. And even I envisage even the issue of not allowing people to exhume is also going to complicate the entire process. Now my question is, just like the person who has been online, what can be done? Is there a way we can have a bank to save this situation in the event someone passes on and this person has been taken for post-mortem? A DNA can be taken and we have a bank to have this process done and reduce on the problems that will come with regard to the estate issues. Then another thing, is there a way probably we can have a bank even when a person is still alive? Can we have a bank for a DNA? If that cannot happen, at birth, can DNA be done immediately at birth? I think there has to be something that needs to be done about this situation, such that all of us are in check. Women are in check, men are in check, and that will reduce on the would-be. I have had a case where a DNA was an issue, and of course everyone thought that this child looks like the deceased, but when the DNA was done, we did it in GAL and MBN, that both laboratories threw the boy out. So resemblance is not conclusive. It's not a conclusive thing, yeah? So that is one of the things that I identified. And then, I don't know if the Administrator General and the courts have also looked at have been enlightened with the works that are done by these laboratories. Because I was told in the event there is no exhumation of a body, they have other ways of finding out DNA. For instance, if it's a girl and the grandmother is still around, they can do a DNA between the granddaughter and the grandmother. Much as it's not done in the country, it's done out of the country, it has an expense attachment on it. And then for the boys, it's also done on their uncles, the brothers to the deceased. But that now comes in terms of if this person was not really a brother to the deceased, then it has also an issue altogether. I think we need to be enlightened more by the practitioners at the Government Analytical Lab about the DNA issues, and then we can pave a way forward as to how we can handle this situation. But otherwise, we can't run away from DNA, we can't run away from exhumation, much as it's also a process that is very expensive to handle.
Council Kawanes, I thank you for that. And I think we saw it, people who read about similar issue. A test was done, I think, in Canada or South Africa between a child and a grandfather. Then it came out showed that the child was not for the family. Now when they did a DNA with the father and the rest of the children, actually the father of the child is the one who didn't belong to the family.
Council? Is that, Council, you can proceed. Sorry? Council, the question was to you, right? The one from Council. It was a comment. Thank you so much. Council, we are still with you. We received another question. that reads, what safeguards has the Administrator General's office, together with our courts, come up with to ensure authenticity of the DNA tests, especially in light of probable compromise and distortion? What safeguards has the AG's office, together with our courts, come up with to ensure authenticity of the DNA tests, especially in light of the probable compromise and distortion? This question comes from Senior Counsel Joseph Henry Kunya. Thank you, please.
Because we recognize, even ourselves, when we think about it, we are not very sure. Even all of us who are here, you can never be 100% sure that your father is your father. Because people are saying, but I resemble my father so much. I gave you the example. So your uncle who resembles your father might be your father. So because of that, to avoid, you find a family that is actually very happy. Very happy. They know we are the children of the Semakulas. And then DNA throws everything into the air. So, pursuit of truth, yes, it is important to know the truth. But at times, when it comes to DNA, actually, at times, not knowing the truth actually can save you. That is just for because it's not the biblical. The biblical is right, that you know the truth, and the truth shall set you free. I agree with that biblical principle. But when it comes to DNA, at times, there is that exception. That actually knowing the truth can put you into bondage. You don't know your father. Now all of a sudden you were a member of the Mamba clan. And by the way, all these are very real examples I'm giving. I'm not mentioning names because of confidentiality. All of a sudden a 45-year-old member of the Mamba clan, by a result from Wandegea, ceases. Now that alone is very traumatizing. But the journey to now know exactly now which clan, especially when your mother is not there. You people, you think these are simple matters? Especially if your mother is not there. Because people say that your mother is the only one who can save you and tell you that, you forget about Mr. Semakula. For you, actually, yours is so and so. Now, when your mother is not there, you are going to go into depression. Because you have ceased to be of this clan. You are now clanless, fatherless. You don't know. And by the way, those people never settle until. I have somebody who came to me and said, I will not settle until I know who my father is, so that I know my clan. So when will you know, especially if your mother is not there? And if she's there, but she's also not sure. So you realize that actually DNA is a very important scientific rule, but it can be very problematic. Like I told you, for me, when babies are mixed at birth in hospitals, to me that one, a DNA test, I don't think anyone would have a very big problem with employing it at that stage to know. And you know there are always mix-ups at birth, babies, so that you go with the baby that. So the safeguards, so we don't necessarily order for DNAs. We require really that the parties go to court
But I think one of the safeguards people have, which is very expensive, is the confirmatory. People mainly go and confirm the tests. And at times, our tests here, when they're taken out, they're overturned, at times they are confirmed. So the only thing I see there as a safeguard is mainly people, until we have a regulatory framework, like my sister was saying, which can now cater for those genetic banks, because a robust regulatory framework should provide for those. The banks, the compulsory DNA testing at birth, and then because she was talking about grandparents, yes, that is the whole argument. How about if your father was not the child of your grandfather? So those are issues. So the whole line is mixed up. So at times not knowing the truth in this particular case can save people. People are dying of depression. Yes. Okay.
Wow. Thank you. You have a question? Yes? Please.
Thank you. Mine is just to share what happened on Bouquet Day, just in line with what Senior Counsel had said. Many years ago on Bouquet Day, there's this elderly man at his mother's door. He's actually kneeling and he's saying all this in Luganda. He's saying, Mommy, please, I'm begging you, let me know who my father is. It was very torturous to watch.
Thank you so much. The issues are very contentious and they cannot stop. So we have a lot more questions, but we are going to request that we first discuss the next item agenda, and then we can see there are some questions that are for the police officer, and then of course for council. But we shall request that we first discuss the next agenda item, and then we shall return to the questions. We encourage you to keep them flowing. It is your role and it's your duty to get that information, so we encourage those questions to come in. But moving first to the next agenda item, like earlier on was said, the next topic is protecting Uganda's children through the legal aid. Your contribution matters. And with us within the House, we're going to have the Uganda Law Society Legal Aid and Pro Bono project that on its own offers free legal support to the vulnerable, the indigent, and the marginalized persons across the country. They are situated in 22 districts across the country. They are called clinics, the legal aid clinics. And in this session, the speakers will unpack the role of legal aid in securing justice for children and show how public and stakeholder contributions are critical in upholding this mission. Today, we are joined by Counsel Sheila Turia-Singura, who is the head of the Legal Aid and Pro Bono project, as well as Counsel Mariam Nansukusa, who is the manager Legal Aid, to guide in the discussion. We shall begin with Counsel Sheila Turia-Singura. Ladies and gentlemen, a round of applause. Thank you so much.
Thank you, Robert. Good afternoon, ladies and gentlemen. Thank you for your time here with us. As earlier introduced, I am Sheila Turia-Singura, and I currently serve as the head of Legal Aid and Pro Bono Services here at the Uganda Law Society. Maybe just to give us a brief background of the Legal Aid project of the Uganda Law Society. We were established in 1992 by the Uganda Law Society leadership then, who recognized the need for offering free legal services to the people that we term as indigent, vulnerable, and marginalized. This came because of what we know commonly, that legal practice and charges by the lawyers in private practice, the fees are quite high. And so for some of our population that is not able to meet those fees, they at the time would be left stranded on how to maneuver the justice system. And so after some benchmarking, the leadership then established the legal aid project of the Uganda Law Society. At that time, we started off with 3 clinics, one here in Kampala, another in Gulu, and another in Kabale. And these were supported by generous funding from the Norwegian Agency for Development through the Norwegian Bar Association. We have, so along the way, we have had other clinics being opened with support from different development partners. And like my colleague Robert mentioned earlier, we now have 22 clinics that are spread across the different regions in the country. So in coming back to today's issue at hand, and on behalf of the Legal Aid Project of the Uganda Law Society, as we commemorate the United Nations International Day of Families, I will speak about the family and protecting Uganda's children through legal aid. The family is universally recognized as the natural and fundamental unit of society. It is within the family that individuals first experience socialization, support, and protection. The strength and stability of families have a direct impact on the cohesion, development, and justice within any nation. And so it's for this reason that the protection and support of families are not merely matters of social policy, but are of legal and human rights concern. When we look at our national laws, we notice that they recognize the family as deserving of state protection and assistance, particularly in times of social and economic strain. I'll refer us to paragraph 19 of the National Objectives and Directive Principles of State Policy that is under our Constitution, and Article 31 of the Constitution of Uganda, which affirm the state's obligation to protect and support families and their rights to protection, care, education, health care, and children's well-being. Strengthening families, therefore, is essential to the broader pursuit of social justice, equality, and human dignity for all. So whether a family is composed of a couple with or without children, or it's a family of siblings, caregivers, or the extended kinship networks, the law must respect them all without discrimination. Now, I know that we know a bit on our statistics as a nation because it's been in the news a lot, but I'll say that as a country with more than half of its population under the age of 18, we cannot talk about families without talking about children, because it is within the family that a child first encounters protection, care, identity, and belonging. And when families are weakened by violence, poverty, or discrimination, it is really the child who suffers the most. Like a wise man and the person that we know and celebrate once said, there can be no keener revelation of a nation's soul than the way it treats its children. These were words by Nelson Mandela, and they ring ever so loudly in our ears today, because we gather here to reaffirm a deeper legal and moral obligation to protect the children of Uganda. This as we join the entire world in commemoration of the United Nations International Day of Families. A stable and supportive family provides the essential foundation upon which all of us can thrive and reach our full potential. When families are empowered, all of us are shielded from exploitation, neglect, and injustice. At the very heart of family justice is the child. Not yet strong, not yet fully formed, but a child full of promise, in that when families are broken or burdened beyond capacity, the vulnerability of that child increases. And if justice cannot reach the child, then it has failed its highest calling. That is why we are here. That is why the Uganda Law Society, through the Legal Aid Project, continues to stretch its arms into corners of this country where children are born into poverty, into conflict, and into silence. We are here to proclaim that children have rights, and those rights are not optional. They are legal, they are constitutional, they are human. Too often when we talk about legal aid for children, we reduce it to custody battles, issues of child maintenance, issues of neglect, issues of guardianship. While these are important, yes, they are only a sliver of the vast reality of childhood in Uganda today. Let's speak the truth as plainly as we can. Children are dying not just from violence, but from neglect. They are not just losing court cases, they are losing their future. Many are learning in collapsed classrooms without chairs or books. I'm sure that we have seen this on the news a lot, especially for the rural schools. You find that they're even learning under the trees, they don't have any desks, it's raining on them even sometimes. So these are some of the things that the children experience. You'll also see that many have not even seen even the basic like sanitary pads. So when you have, you'll then have some of the girls missing school because of such issues. Others have also never been vaccinated or treated when they are ill. Yes, we may call it poverty, but it is injustice. It is a violation of rights. So when, for example, you have a child walking 10 kilometers for water or 15 kilometers to school, or when a sick child is turned away from a local clinic because the parent cannot pay, we are not just dealing with an inconvenience. We are witnessing silent cruelty and real tears from children. And legal aid, and possibly the legal fraternity, must rise to this wider battlefield beyond the courtrooms that we go to represent these children or to represent the families. We must rise and go into villages, into homes, into hearts of people, and create change so that the child gets the justice they deserve. The Legal Aid Project of Uganda Law Society was founded on this broader vision. And like I mentioned earlier, from just the 3 clinics that we started with in 1992, we now have 22 clinics across the country. And LAP, as we know it and commonly call it, has become a lifeline for the poor, the voiceless, marginalized, and vulnerable women and children and men, but especially the women and the children. So we do not just litigate, we mediate, we counsel, we empower, we walk into prisons, schools, health centers, radio stations, remand homes and communities, not just to speak for people, but to awaken their voice within them so that they are also able to speak up. Every year, we have about 20,000 Ugandans passing through the legal aid hands, many of whom are children or their caregivers. Some are victims of crime seeking redress. Others are children in conflict with the law. Some come in silence and others come in tears. But all come in hope that this country still has room for justice and still has a beating conscience. LAP offers that hope, not as charity, but as a right. And yet, even with all this support that we give, our work has to go further, especially in this era of the radical new bar, guided by the Rnblive Vision 2060. The truth is, a child cannot enjoy rights in a vacuum. You cannot talk about legal rights to a child who is hungry. You cannot speak of protection to a child living on the street, surrounded by darkness and sexual abuse. You cannot preach about dignity to a child locked in a cell with adults, tortured into confession. We must see the child in full, not just as a legal subject, but as a human being whose body, mind, and spirit must be nourished. That means access to clean water, access to safe schools, access to health care, birth registration, protection from child marriage, and protection from child labor and trafficking. It means treating every child not as a project, but as a person. This is how legal aid has evolved to fight not only for justice in the courts, but justice in the lives of children. Today, as we speak, many children are locked in cycles of abuse, and they are told to be quiet. Many suffer in silence because they do not know where to go. The law may exist, but access remains a theme. That is a myth. That is why legal aid is not just an intervention, it's a resistance. It is the bold defiance of a system that has forgotten its own children. So legal aid says to the child, you matter, and your pain matters to us, and we will not ignore you. But like we know, LAP, of course, cannot do all of this alone. And so we especially appreciate our partners who have worked with us and played a vital role in advancing access to justice for the indigent, the vulnerable, and marginalized. And while, yes, it's been a journey, the road is still longer that we will need to cover. And so we make a call to, first of all, the government of Uganda to make legal aid a budget priority. We have for long had the legal aid bill before Parliament, in and out, being tabled and pushed back, tabled and pushed back. So our call is for government to not delay the passing of the legal aid bill any further, and to fulfill their constitutional duty to ensure equitable access to education, clean water, and quality health care for all. We also call upon the Justice, Law and Order Services actors to join hands with Legal Aid Project and Uganda Law Society in fighting for the rights of children and other vulnerable and marginalized groups of people in our communities. And to our fellow lawyers, our members of the Uganda Law Society, let's not let pro bono be an act of pity, but let it be a pledge of our profession. Let us all dedicate ourselves to giving back, lifting up the weak, and making the law live. You can kindly make an appointment with us at any of our branches, our legal aid clinics, to discuss and design a bespoke pro bono arrangement with you, your friends, or your law firm, which can be on an annual basis, to ensure that you stamp your mark on the record of child protection through legal aid. We give you our assurance that we will be open-minded and flexible in attending to you. For the children are not just tomorrow's leaders, they are today's citizens. They deserve dignity, they deserve protection, they deserve a legal and a generally good system that works for them. Because if the law fails them, then the law has failed all of us. So today, as we commemorate the United Nations International Day of Families, let us reflect on our omissions and actions, and most importantly, unite to enable justice roll on like a river to every village, every home, every child, leaving no one behind. Thank you for listening to me. Not yet. I'm going to call her. So, as I mentioned earlier, we've not walked the journey alone as legal aid. And so allow me invite our manager legal aid, Mariam Nansuksa, who on behalf of the Legal Aid Project and the Radical New Bar will specially recognize a few of our members of the Uganda Law Society, who we commonly call pro bono advocates, who have stood out in walking the journey of advancing access to justice through legal aid and pro bono with us. Thank you.
Thank you so much, Sheila. Good afternoon, everyone. As already being introduced, my name is Naskusa Mariam, the Manager Legal Aid and Pro Bono Services. Before I recognize the pro bono advocates who assist in protection and justice of the children, me as a legal practitioner, I'm passionate about the child justice. I've practiced it for over 8 and above years. And when you are handling especially the vulnerable, the marginalized, and the indigent, you have to be very patient. You have to be very patient with them, because these are the children who need your help. If you are not patient, you cannot assist. You cannot accomplish the mission as an advocate. As you see, the statistics, women are most passionate about the children's justice in litigation compared to men. And I can give you a scenario. I handled a case in court. It involved 6 children. This is a man who refused to cater for the children. And the woman was not working. But the man had the guts of paying a lawyer, instruction fees, and transport to go to court, and failed to cater for the children, and was saying they're supposed to join UPE, and used to give them 60,000 shillings a month to cater for their feeding and clothes. You can find that it is unfair. As the legal practitioners, where is justice? How can you go to court and defend such a man who has refused to take care of the children? Moreover, 6 children, and they are suffering. As we commemorate the United Nations International Day of Families, we cannot fail to recognize the pro bono advocates who are passionate about children's justice in Uganda and internationally. Today, the Radical New Bar, in a special way, wishes to honor distinguished group of advocates whose dedication to justice has profoundly impacted the lives of the Ugandans, mostly vulnerable, our children. These advocates have not only stood at the forefront of the child protection efforts, but they have also served as powerful voices in the courts of law, representing children with a courage and commitment. Through their legal expertise, safeguarded the rights of countless children and upheld the principles of dignity and protection that every child deserves. It is with deep respect and gratitude that we recognize their extraordinary contributions. The first advocate to be recognized by the Radical New Bar in her absentia is Advocate Adukule Winnie. Advocate Adukule Winnie enrolled as an advocate in 2005 and is currently the executive director of Free Child Uganda, an NGO that focuses on ensuring access to justice for juvenile offenders. For the last 8 years, she has focused on enhancing access to justice for juvenile offenders, and she has pioneered the court sitting at Naguru Remand Home at the peak of COVID-19 in 2020, which built on the foundation and made the justification for having the remand home gazetted as courts. We clap for her for that. As the Radical New Bar, we honor you, Advocate Adukule Winnie, for being a pillar of hope and a guardian of justice for our youngest and most vulnerable citizens. The impact of your work will echo for generations. The second advocate to be recognized by the Radical New Bar, we have Advocate Kabonesa Evelyn, who is present here today. You can stand for recognition. Advocate Kabonesa Evelyn enrolled in the year 2006 and is currently practicing under Mulindwa, Kasule, and Kampana advocates. Previously, she worked as head public defender, Eastern Region, and occasionally trains CID police officers at Chibuli on trial advocacy. Kabonesa is a passionate pro bono advocate with keen interest in promotion of children's rights and has represented children in courts of law. As the Radical New Bar, we thank you for being a champion for the children's rights and a beacon of integrity in this virtual mission. Your contribution is really valued. We thank you, Advocate Kabonesa. The third advocate to be recognized is Advocate Nabukera Judith, who is present today. Advocate Judith enrolled as an advocate in the year 2014 and is currently practicing from Lule, Godfrey, and Mulumba Kampana advocates. We extend our heartfelt gratitude and deep admiration to your advocate for dedicating the protection and promotion of children's rights. Through the tirelessness, advocacy, compassionate leadership, and a steadfast commitment to justice, you have made incredible impact to the lives of the countless children in Uganda. Thank you so much, Advocate Judith. Your work has not only safeguarded the most vulnerable, but has also inspired hope, fostered change, and advanced the cause of dignity and safety for every child. The positive outcomes of your efforts will be felt for generations to come. As the Radical New Bar, we thank you for being a champion for children's rights and a beacon of integrity in this vital mission. Your contribution is really valued. Thank you so much. We have another advocate, now is joined judiciary, is a judicial officer. We need to recognize his effort. His Worship Chizito Deo Lutalo, in his absentia. His Worship enrolled as an advocate in the year 2011 and has since crossed over to the bench. Is currently serving as a Magistrate Grade 1 in the judiciary. Before joining the judiciary, Deo worked as a legal officer, later as a senior legal officer under the Legal Aid Project of the Uganda Law Society. As the Radical New Bar, we extend our heartfelt recognition to His Worship Chizito Deo for his contributions to the promotion and protection of children's rights during his years of dedicated service in legal advocacy. Before his transition in the judiciary, His Worship Chizito was passionate and committed defender of children, tirelessly represented minors in the courts of law and working to ensure that every child received fair treatment and justice. His dedication to child protection laid a strong foundation for meaningful change and inspired many within the legal aid community. As he continues his journey within the judiciary, the Radical New Bar celebrates his past efforts and the lasting impact of his work in advancing the rights and the welfare of the children. His legacy of compassion, integrity, and justice remains guiding light for all those who strive service the most vulnerable in our society. Thank you so much, Your Worship Deo. The next person to be recognized is Advocate Nampija Ruth, who enrolled as an advocate in the year 2014 and is currently practicing under Jingo, Sempija, and Company Advocates. Her work has not only safeguarded the most vulnerable, but has also inspired hope, fostered change, and advanced the cause of dignity and safety for every child. The positive outcomes of your efforts will be felt for generations. Thank you so much. We have another male advocate who is passionate about children's justice and is present today. He's called Advocate Goloba Abe. You can clap for him. It is very hard to find men who are very passionate in that area, but he's among the few. Advocate Goloba enrolled in the year 2017 and is currently the managing partner of Naikoba and Goroba Advocates. Previously, he volunteered at Legal Aid Clinic of the Development Center before joining the Runa Advocates. Now you see where the passion is coming from the legal aid service provider. We clap for him for that. Driven by the pursuit of justice, and I believe that everyone deserves a voice in the legal system. He has constantly represented juveniles on pro bono basis, for which the Radical New Bar recognizes him today. Thank you so much, Advocate Goroba Abi. We have another advocate who is very passionate about the children's justice. Is called Awero Sarah. Awero Sarah enrolled in the year 2008 and is currently practicing at Nansubuga Awero and Company Advocates. Her work has not only safeguarded the most vulnerable, but has also inspired hope, fostered change, and advanced the cause of dignity and safety for every child. The positive outcomes of her work will be felt for generations. As the Radical New Bar, we thank you for being a champion for the children's rights and a beacon of integrity in the vital mission. Your contributions is truly valued. Lastly, but not the least, we have Nabire Susan. And Nabire Susan is her absentia. She's an advocate who enrolled in 2012 and is currently practicing at Law Development Center Legal Aid Clinic. Through her tireless advocacy, Susan has been a powerful voice for the vulnerable children, ensuring that their rights are protected and their best interests are upheld within the justice system. Her compassionate approach, deep sense of justice, and dedication has made a meaningful difference in the lives of the countless children and families. Her work exemplifies the true spirit of service, grounded in the empathic professionalism and a steadfast belief that every child deserves protection, dignity, and a fair chance in the life. We honor Susan for her exceptional contribution, and we thank her for her continued commitment to building a more just and child-friendly society. Those are among the advocates who are passionate about child protection, but it's not the least. There are many more who are passionate about child justice. As the Radical New Bar, we appreciate all the advocates on this day of the International Day of Families. We are celebrating you all pro bono advocates for the effort you are putting to support our children who are homeless and those who are not homeless, who need justice and protection in our country. Thank you so much. At this juncture, we need to have a token of thanks to the advocates who are present here. And I call upon the Vice President to hand over this token to the advocates present. Thank you so much.
Thank you, Mariam. And to our pro bono advocates, we do celebrate you today for the immense contribution you've made, for not letting us walk alone and for walking the journey with us. My role right now is to just give a token of appreciation. And I think I'll have each of our advocates, beginning with Advocate Kawanesa Evelyn. Please come over. And please allow me. I won't let Advocate Kawanesa Evelyn leave without saying a word in a minute. Please speak to the congregation.
Good afternoon, ladies and gentlemen. I'm glad that I'm being recognized today. It has been a long journey working with legal aid. Once I started with public defenders, right in Ginger, and then later on, when I joined private practice, I continued with this work through Legal Aid, Uganda Law Society. I thank Uganda Law Society for making the journey quick for us, all the advocates. They went out to the different judicial officers, enlightened them on this project, and every judicial officer that we went before made things easy for all of us. We thank you, the judiciary, for making things easy for all of us. We thank all the other departments. I've interfaced with Council Goloba on a few files, and he has always made things easy for me. And I believe to all the other advocates, thank you so much, and the entire department, the Administrator General. To all the young lawyers, I know many of you come in thinking there's a lot of money that you have to get out of this, but it's so good for us to join and give a service to the different communities that need this service. And what thrills all of us and keeps us going is that little smile that you put on the face of each and every indigent person that has come in for this service through legal aid. I call upon all advocates to, at least once a year, to offer this service to an indigent person. It could be through Uganda Law Society or through an indigent who walks through a chamber. It could be something that is given back, even if it's not practically through Uganda Law Society and seen by everyone. The Lord that we serve always gives back to you. I have impliedly got a few good things out of it. When you go before a judicial officer and you present your case very well, sometimes you get phone calls from judges, others thanking you for helping out an indigent, others sending you more clients, but this is something that comes as an added advantage to the service that we render to these indigent people. So I call upon everyone to come and join the project, and let's give a smile to the different people that are in pain. And to all the parents, much as we are fighting this battle, it all goes back to the family, the setting. I call upon all the different agencies, Ministry of Gender, various religious bodies. We need to go back. We need to go back to the family setting. Parents are absent, and children are being taken care of. Maids, they are being taken care of people on the streets, and we don't have a lot that we are gaining out of them apart from seeing convictions time and again of murders because of psychological tortures from the communities, from the parents, domestic violence. Schools, Ministry of Education should think about sending or having a requirement of counselors. Since the parents are not available, these children need another third party to talk to in the event they have issues. We need lawyers to come on board and teach children in various schools about human rights so that they do not get into sexual offenses, they do not get into capital offenses like murder, rape, and all the other cases that we have along. It's a collective effort that I'm calling for from the various stakeholders. Let's put a smile on all our children wherever we are. Thank you.
And now Advocate Nawokera Judith, one of our most active pro bono advocates since I joined pro bono. Now, Advocate Nabokeda, please can say a word or two to the congregation.
Good afternoon, ladies and gentlemen. I feel privileged that I've been appreciated for the service I've offered, the services I offer ULS. I'm a private practitioner, and most of you know for us in private practice, it's all about money. But I always feel I have the need to give back to society, especially the indigent, because some, much as they may be able to afford their services, circumstances fail them to be able to afford that service. So I always feel I have the obligation to give back to society. I have a humble request to the fathers in the country that please always be present in the children's lives, especially the boys. We have neglected the boy child so much. And however much we try to advocate for girls' rights and women's rights and we leave behind the boy child, we shall be doing nothing. Because if they are not mentored well or nurtured well, it is the reason why we are having single mothers. The rate of single mothers is rising because we are neglecting the boy child. So I call upon parents to please, as you try to nurture the girl child, don't forget the boy child. Thank you.
And finally, another advocate present in the room, Advocate Golova Abe. Please clap harder. Okay, Mr. Golova, please come and speak to the congregation in a word or two.
Well, thank you very much, the Radical New Bar. And also, I thank God that I've been recognized amongst all the advocates that we have in Uganda, over 6,000. Some may say that this is not our obligation, but under the advocates' provision of indigent, services to the vulnerable, all advocates are entitled to provide pro bono services. I've been doing this since I left LDC, and in most cases, one would wonder why should an advocate provide pro bono services? But it is good in a way that wherever you do so, there is a way God does it for you in the commercial transactions. Because I remember I've been doing duty counsel in some courts, and wherever you help somebody, a child, a juvenile, next week again you get a private client. So I just thank God, the Law Society, for having recognized us, and also thank God that I've been recognized. Thank you very much.
Thank you very much. Right. Can I please first have all the three advocates here, the ones in the room, Madam Evelyn and
Thank you so much.
Wow, thank you so much, the Legal Aid Project of the Uganda Law Society. That was quite a deep session that has touched very many lives. We want to thank you, the Legal Aid Project of the Uganda Law Society. We cannot say it any better, but also as we celebrate these beautiful souls, these advocates in the house and those that are absent, we don't know how better to say thank you. May the good Lord bless you. Like you have said, you've already gotten blessings. Not very many of us get phone calls from judicial officers. It's not an easy thing, and that takes so much hard work. Thank you for showing the passion. May the Lord bless you for all the work that you do. And for those that are absent, the advocates that have been celebrated, wherever you are, we want to send blessings of God unto you as we continue to fight for the child and all other vulnerable people under the auspice of Celebrating Family. Would like to ask that God bless you in your endeavors. Thank you so much. Ladies and gentlemen, as we come to the end of the session for the day, we want to thank you for continuing to be with us. The Radical New Bar, under the able leadership of our President, Isaac K. Semakade, who continues to give us the blessings, is very appreciative of your time. Those online and those physically present, we continue to ask you to stand with us as we continue to partner with the different agencies in the country, and as the Pearl of Africa, Uganda, all we can say is for God and my country, that God is the one who replies and pays us back for the work that we do, especially that work that is out of passion, including the pro bono advocates who have been recognized, and of course the Uganda Law Society, especially the Legal Aid Project. Ladies and gentlemen, we earlier on had a few questions that had come in. Without further ado, I would like very fast, we would like to pose one question to the representative from the Uganda Police Force that came in earlier on, and just within a very short time she will take us through that answer, and we shall henceforth invite the Vice President of the Uganda Law Society to share with us his remarks as he closes the session for the day. Madam Afande, if you may. The comment starts, we thank the Uganda Police for the work done in solving family disputes. It's the first time I'm hearing about the Child and Family Protection Unit. Does this unit exist in up-country areas, or is it only at the headquarters? Number one. The other question, my question is on the issue of corruption. These days, people no longer want to go to police because police officers want kitu kidogo in courts. How can we promote public trust in the institution? Afande, the second question is abstract. I would like you to just use your wisdom and answer in a few words, please. Thank you.
Thank you very much. The first question goes to the CFPD. Actually, we are not a unit. We are now a department. And our offices are all over the country. Every district where you go to, every police station, we have a child and family protection officer with their staff. So it's not only at headquarters, because headquarters, it's us who transfer them, and also we recruit, the police recruits them, but they are all the country. So our offices are all over the country, that any other person can ably walk in there and get the necessary service. Then secondly, the issue of corruption, I would ably advise that as police we have structures and we have levels. And that office that you walk into, they are supervisors. When you go to the station, we have a DPC, who's the district police commander. We have a CID office. So when you walk into that office and you sense any sign of corruption, kindly report to those various police supervisors. As well, we have a police standards unit which sits at Kololo. So if you feel there is anything that your case has been handled in a very awkward way, kindly reach out. Even the numbers are saturated. We can ably guide you and also follow it up. Thank you.
Thank you very much, Afande, for that brilliant answer. Ladies and gentlemen, without further ado, we would like to thank you once again for bearing with us. Our time is fast spent. We would like to take this opportunity to welcome the Vice President of the Uganda Law Society, Advocate Asimwe Anthony, to give us his closing remarks and in representation of the Council. Thank you so much.
Thank you, Robert, once again. I know it's been a long day and our time here is fast spent. I'll try to be as brief as I can. Allow me appreciate our guests for today. Senior Counsel Kulova, who is also my colleague. I'm proudly associated with him because we do teach together at the Law Development Center. Same subjects, actually. Madam Nabukera from the Police Department, thank you for honoring our invitation. Members of Council who are all online. I'm the only one here physically, but they are online following. We have our members in the room, most importantly, the pro bono advocates, those who have been recognized and those who have not been recognized but are here with us. The members online and the staff, members of the Secretariat who are here with us today, who have always made this possible. I do extend my appreciation and thanks, and from the position of Council, we do appreciate and thank you for everything. Let me also congratulate the pro bono advocates who have been recognized today for your contribution. It is not very easy to offer pro bono. It's not very easy to give the support that you give. It's a sacrifice. And some of you may not know, when you speak legal aid and pro bono, I usually refer to myself as a success story of legal aid and pro bono. I've had all my life, all my practice in life, I've worked with legal aid, I've done pro bono, and actually, the colleagues have been recognized, we've worked together while I managed the pro bono project of Uganda Law Society before I crossed over. And this is the one thing I'll tell you, every time you had, the head legal aid and pro bono tell us about the milestones LAP has had over the years since 1992. But LAP is definitely overwhelmed. You cannot handle, you cannot manage to take up all the matters, all the cases that would come up. Kulova rightly stated how the biggest number of cases would have family-related cases, children cases, land cases, and again, just so you may know, out of 10 Ugandans, I think only 2 can afford legal services. They can afford to pay a lawyer. And it's so unfortunate. You also had, in the speech of the head legal aid and pro bono, talking about or calling upon government to fast track the national legal aid law. It's unfortunate that the government, our government, has not found it pertinent to pass such a law. So the indigent, the marginalized, the poor, the vulnerable, who by the majority of them are women, children, deep down in villages, and others are in town, are left at the mercy of a few legal aid service providers and the pro bono advocates. But again, my experience from pro bono and why it is important that we do, as the Radical New Bar, recognize specific individuals is every time you'd pick a phone call, you pick a phone and make a phone call to any advocate that, listen, I have here a file, a pro bono file. We have a client here, but we are overwhelmed. The legal aid staff cannot handle all this workload. You literally had to beg. But there are those individuals who would even come and ask, they would even check on you. I remember Evelyn, Judith, even Goloba, they would even call and say, once in a while, Goloba would call and say, I'm here at court, there are people stuck, what can we do? These ladies and gentlemen would even check on us in office, do you have files? We are here to help. And the reports you would get from the beneficiaries, the people, the clients you've referred to them were immense. These are acts of kindness, professionalism, that we cannot take for granted. Just before I came here and, I was attending a symposium just at Protea. And it's organized by some of our members, called Estate Planning Symposium. It's interesting how most people, when you talk of estate planning, and this is what I learned, what I appreciated, they imagine it's when someone has died. But one thing I got to appreciate is that if there are not disputes, these people will not need lawyers. But what is the cause of these disputes? It goes back to the structure of a family right from the beginning. How have you, as parents, structured? What values have you instilled in these, children? Even as, we're discussing issues of DNA, what causes all this, if there are particular values that have been instilled from a young age by the parents, and if there's mutual respect, some of these people will not even come up to begin, questioning whether this is my brother or not, whether this one is entitled to, property or not. And like the previous speakers have said, it's very clear. If you go to our court systems, the biggest number of cases, I do practice in that field, administration of estates. You'll be shocked at the nature of cases there. Families torn apart when their parents are gone. Others are torn apart beyond repair. Unfortunately, it's usually those who cannot afford, the vulnerable ones, they're the only ones they're the ones who are always on the losing side. So the question I would really ask the members of the bar, they're the advocates, or any other person, not necessarily advocates, what contribution will you make? What do you want to be remembered for, to have contributed to society? I know for members it's all about making money. Every client walks into someone's chambers with a case, someone is looking at the pocket. That's how we are structured. A client who walks in is business. A client who calls you on phone is business. Any referral is business. That is how lawyers conduct business. That is their source of income. But not every client should be a source of income. If as advocates, as lawyers, we cannot speak for the voiceless, then what are we good for? If we cannot support those who cannot support themselves, then of what use are we to society? For me, this is, as we celebrate the International Day of Families, it is a call to all the members of society, the advocates, the various stakeholders, justice, law and order sector, the judiciary, to always consider, always give priority, even while handling matters, to cases that involve children, because they're the most vulnerable. They are always in a vulnerable position. And even other cases, they could involve adults, parents fighting for, paternity. Let's look at the interests of the child. And also we need to, recognize that these children at our mercy, everyone has a contribution to make. Everyone has a role to play. And as the Uganda Society, as the Radical New Bar, we take some of these matters very important. Issues to do with rule of law, access to justice. That is why our legal aid project, legal aid and pro bono project of Uganda Society is here. That is why we give the support we do, even amidst all the hardships, as you're all aware, that most of the work that is done by legal aid and pro bono is donor funded. The ladies you saw here have to struggle, think of who is going to give us another donation, which development partner is going to help us support children in remand homes, support those people who are rotting in prison but they cannot afford to pay for their legal services. Those women who are deep down in the villages suffering because of inequality. Those ones who lack knowledge, which we should actually be imparting, which should be the obligation of government. But like I said, it's these, ladies and gentlemen you see in the legal aid and pro bono department at the Law Society and the staff across the country, 22 districts, some of whom actually have to go months and months without pay because the donor funding has come to an end. But they still have to offer a service. Imagine you're representing someone. These are some of the questions I used to get from some pro bono advocates, because an advocate is offering a free service, but they require, filing fees at court. They require stationery. Others have touched their pockets and they're tired. And you're telling this person that, listen, we no longer have funding. There's nothing as hard as explaining to a client that, because we no longer have funding, we cannot come to court, when they are remaining with one witness to complete the case. It is midway, but you become indigent yourself. Yeah? You're incapacitated. You cannot offer the service. Those are some of the challenges we face. And the only way we can, reduce on these challenges, the only way we can address these challenges is having proper corroborations with various, stakeholders, and also, most important, calling upon the people, the government, to take this as a serious matter of national importance, because it does not only affect the economy of the country, but also, the social setting. It affects both the socio-economic setting, and it impacts the society negatively if some of these disputes are not resolved, if these people are not supported. So as the Uganda Society will do our part, we do call upon the rest of the stakeholders to do their part, and we ensure that access to justice and rule of law in this country is a reality. That is what we stand for, and that is what everyone should stand for. So thank you very much for listening, and once again, allow me appreciate our guests. Please clap for them. The Office of the Administrator General is very, important in the work we do, and police. These are some of the institutions we feel we can work together closely. If each of these institutions can contribute the way they're supposed to contribute, we shall have, a reduction in some of the cases and the challenges we are having. We shall contribute something to society together. So thank you very much for always, showing up whenever I call upon you. And we do pledge to continue working together with you so as to contribute to the development of this, country. And improving strongly on the aspect of access to justice and rule of law in this country. I thank you very much. Thank you very much for listening.
Thank you so much, Mr. Vice President. We appreciate your words of wisdom. You've crowned it all well. We normally have a practice that invites the guest speakers to the podium or to the floor to take a picture in memory of what has transpired, and also to thank them for their time. We're going to request that the speakers, alongside the Vice President, shall come to the front to take a picture, and thereafter, as well as the advocates, the pro bono advocates, but separate from the speakers for now, please.